Oftentimes, clients come into my office and tell me they were beat up by the police, or that a loved one was beat up by the police, and that they had to go to the hospital before they were booked in jail, and they've been charged with resisting or delaying a police officer, and they have physical injuries when they come into my office. And they ask me, what can I do? What recourse do I have while I go through the criminal justice system? I always tell them the same thing, that under California law, we have a right to ask the court to see the personnel records of the police officer that hit them. That we have a right to have the court, in what's called an in-camera hearing, have a police official come to the courthouse, look at their records to see if there's any evidence of prior allegations of excessive force, of untruthfulness, of falsifying police reports. It's a critical tool that we use in an attempt to gather all the information so we can best defend our client and ultimately lead to justice for them by way of filing a complaint and potentially civil litigation against the offending officer. People often ask me, what allows you to do that? And I tell them the same thing all the time, the law. There was a case called People v. Pitchess. Peter Pitchess was the sheriff of LA County for years. And an LA County sheriff's deputy allegedly beat up an individual who was then accused of a crime. That person's attorney wanted to look at the personnel records of that officer, see if he's been accused in the past of unlawfully and excessively striking others, or lying or falsifying police reports on cases where he did strike others. Sheriff Pitchess said, no, I'm not going to give the records to that attorney. The Superior Court said, yes, you are. And now, as a result of that case, and all the accused in California who allege that and have been either beaten by police officers or believe the police officers are lying and can demonstrate some evidence to that point, have a right to a court to review the officer's record to see whether or not there's any information out there that they can use to exonerate them in their current matter. In regards to Pitchess motions, our office routinely will run those motions in an attempt to gather information to assist our client. As a former 13-year now retired police sergeant, I know the other end of it. I had many a Pitchess motion run on me when I was a police officer where my credibility was looked into by the accused and their attorney. I recall not being very happy about that when I was a young officer, but I realized that as a police officer, and I realize that of course today as a lawyer, that we give police officers great powers. We give them the authority to stop people, to take away their freedoms, ultimately give police officers the authority to use deadly force if necessary. With that authority must come great scrutiny. We must be allowed as a society to look at and critically review police officers and their actions. Without that ability to do that, we would have nothing more than a police state, and it would be in violation of everything we believe is fundamental in an American way of life, from our Constitution to how we raise our children to how we live our lives. We must always be able to look at government with great scrutiny and say to them, we want to make sure you did it right. I'm Mike Scafiddi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.